So welcome and thank you for attending, everyone. We've got a great lineup for you today. You'll hear some great stories and experience that will hopefully be of help to you and your clients. Before we begin, want to let you know that we are recording the session today, and it will be posted on our YouTube page when editing is done. I'd like to introduce the leaders of NGBM, Blake Waddell, Lindsay Gibson, and myself. I'm Jay Nadler. We run the program. I have to give extra credit today to Blake. He did most of the heavy lifting for this session. For the people joining us for the first time today, NGBM came from the CGIB membership and the need for more group benefit education for advisors. We started in 2020 and we have had almost 4 years of providing educational content with the simple goal of helping advisors be better advisors. We have no sponsorship. We do not allow anyone to sell anything. And these meetings are open to everyone in the industry, and we do not charge any fees. The sessions are usually between 90 and 120 minutes and do not have any credits. We are bare bones. We just hope to give you really good education. As you will see, advisors who attend these sessions are happy to share their knowledge and experience with everybody in the session. If you're a new advisor, someone with 30 years of experience, we hope you learned something new today. If anyone here today is not on our email list, please email us and we'll add you. It's ngbmcanada@gmail.
Oh no. Gmail.com.
Of course, Jay had to freeze. Yes, at gmail.com.
All right. I'm going to, I'll do the first introduction while Jay unfreezes. So I get the privilege to introduce our first speakers today, Rob and Patricia Van de Capelle. I've known Rob for over a decade. He's a huge supporter of both the NGBM and CGIB, and is always giving back to the industry. So of course, when I reached out to him, well, the group reached out to him to ask if he'd be willing to share their story, he said yes immediately. I'll never forget the day in 2019, I was in Saskatoon with Jordan Bullhose, and we were starting a breakfast there. And I had to call Rob about a group quote. And when he answered, I knew instantly something was wrong and my heart sank. He said, Linz, Pat almost died and was in the hospital. This is where their frustrating and long road ahead started. And I'll pass the floor over to Rob and Pat to share their journey. Go ahead, Pat, or Rob and Pat.
Thanks, Linz. Thanks for that introduction. I'm going to share my screen here. If I can figure that out, bear with me for 1 sec. Someone can just let me know when you actually see the screen. That would be great. Can you see it?
Not yet.
Is it working?
Not yet.
Oh, I got to hit the share button. That probably works better.
Rob, can you turn up your volume a little bit too? And we can see it now.
You can see it now?
Yeah. People are having a hard time hearing you.
Is that any better? Can you hear me better now?
No.
Still a bit quiet. Do you want to speak as loud as you can?
Now what I'll do is I'll put on my speaker, my thing, but I'll have to relay anything to Pat that is asked because she won't hear it. Is that better? Is that better now?
Oh, way
Yes.
better.
Okay. Yeah. Okay. All right. Thanks, Linz, for the introduction. And yes, I can admit that I was pretty emotional when I spoke with Linz that day. And as you will hear, it happened more than once through this journey. And to be honest, both Pat and I have gone through many emotions. Sadness, fear, anger, joy are only a few. And just so everybody knows, this is mostly Pat's journey. I was sort of been the guide from the side, but part of her condition is her voice comes and goes. And she's, to be also honest, she's not feeling the best today. So she may or may not make it for the whole presentation. So I'm going to be doing most of the speaking today. And whenever my wife gives me the nod to be able to talk more than her, I'm going to take advantage of it. And just as I start, I'm just going to mention that this is our experience and our journey. It has nothing to do to reflect on Cowan Insurance, which is where I work. So I'm just saying that so I don't get in trouble. The agenda, what we're going to go through today, a little quick introduction, some history, our timeline, surprises, fears, and takeaways. And then if there's any time for questions, I don't know if we're going to do them now or if we're going to do them all generally at the end. So Pat and I both have experience in the insurance industry. Pat worked as a senior underwriter for specialty lines at Frank Cowan, which is now intact, for over 30 years. And the past 10 plus years, I've worked in the group benefit industry, and currently I'm a consultant at Cowan Insurance Group. A little bit of history, how we got here. So at age 18, Pat was diagnosed with an autoimmune disease called Wagner's granulomatosis with polyangiitis, or GPA, formerly called Wagner's granulomatosis. It's an uncommon disorder that causes inflammation of the blood vessels in your nose, sinus, throat, lungs, and kidneys. It's an autoimmune disease. So through COVID, we were quite cautious because as an autoimmune disease, as I'm sure most of you know, Pat is on drugs to lower her immune system. So even a cold is a bad thing for Pat. So when it's COVID or a bad flu, that's even worse. So we were quite safe during COVID. The doctors that Pat has, and people in Canada, as you again know, have trouble finding doctors. Pat has a plethora of doctors, from a GP to a rheumatologist to a kidney specialist and a liver specialist. And they're all very good. They all partner and work together. So that helps Pat. And her drug cocktail is longer than the Confederation documents. So it is quite big. With the disease or the drug cocktail she was on, the disease went into remission. It doesn't mean we didn't deal with scary moments along the way. When she was diagnosed at age 18, the doctors told her if she hadn't been diagnosed when she came in, she had approximately 6 weeks left to live at that time. Due to complications from the conditions in 2006, she coded after routine surgery and had to stay in ICU. It was on life support and did need the paddles to bring her back to life. It was touch and go, and it provided us, probably more so me, a glimpse of how fragile life really is. In 2019, where Lindsay alluded to, we had a setback, or she had a setback, and she contracted an unknown virus from where we don't know. It had come and gone through her body before anybody detected it, and because of that virus, the drug that was keeping the GPA in remission, it was a cancer drug called methotrexate, started to attack her liver. And then the 2019 health episode started us on our LTD journey. So we'll go through a timeline from beginning to end. So November 2018, Pat seeks medical help for side, stomach, mid body pain from at least 5 different doctors, the 5 ones that I listed. CTs and ultrasound showed nothing. There was nothing, they couldn't find anything why there was pain. September 10th, 2019, Pat works until about 1:30 mid-afternoon, drives herself to the ER. They diagnose her with IBS, send her home with Buscopan and morphine for the pain, prescriptions for those drugs. September 12th, a couple of days later, I came home from work and I woke Pat up. She's incoherent, unstable, unable to form any sentences. So I rushed her back to the hospital. They put her in ICU and drained 4 liters of fluid from her abdomen. September 17th, Pat transferred from Woodstock Hospital to University Hospital in London, diagnosed with NASH, non-alcoholic cirrhosis of the liver. Basically the backup from her liver not working was infecting her entire body, and the infection had moved up to her brain, and that's what was causing the incoherent concerns. Almost 4 liters of fluid again drained from her abdomen. She had high pain, weakness, fatigue, fever. Look at that, a typo. It should be chills, not shills. She had no appetite, and she lost a lot of weight. So 3 weeks later, or 10 days later, she was released from the hospital in London, and she was assigned a case manager from the insurance provider. in speaking with my clients who have went through LTD with their employees, uh, they have the same experience with different providers. So I'm not going to throw the provider we deal with under the bus. At least I'm going to try. If I mention them, it's by accident. So she was assigned a case manager, Aaron, from the insurance provider. October, November, she had multiple visits to different doctors in many different specialties. And then November 2019, Pat's STD was approved till December 2nd. The GP offered to speak to the provider if needed. Pat sent the specialist letter to the provider, and the GP information was not yet received, according to the provider. Pat confirmed that 73 pages were sent to the GP from the GP to the provider with a return to work date of April 2020. The provider, a new contact was provided at the provider, Ari. Uh, on Friday, I don't know the date, sorry, 4:45, a telephone call with Pat and Ari. Uh, the extension was declined. So not only is the extension declined, but at 4:45 on a Friday, they tell Pat it's declined and she's expected to work the following Monday. So it's 15 minutes left in the workday, and there's no way we can deal with anything. Pat was panicked. She was in tears, sitting on our couch. Um, Pat asked about an appeal process, and the appeal process takes 2 to 3 days. So in my world, I would think that if you're telling someone they're declined, you should at least provide enough time for the appeal process to be worked through. Um, Pat was expected at work on a Monday. Luckily, Pat was worked at Cowan long enough that she knew enough people who to call. So she called the VP of HR, who then reached out to the provider, the VP of LTD or disability, I guess. And the STD was extended to January 2nd through the holidays. Um, the biggest problem here was on December 1st, Frank Cowan was sold to Intact. So now we're dealing with an employer that is no longer Pat's employer because they were sold. Um, and that just creates some other problems. December 2019, January 20th, 2020, uh, the doctor heading Pat's case agrees to no improvement, agrees that there's no improvement and LTD will be required. Um, the provider saying no updated information. The doctor confirmed everything requested was sent. January 6th, the LTD approved and letter sent to the employer. The ongoing concerns here that Pat and I are dealing with, mostly Pat, again, I'm trying to support Pat. Ongoing weakness, stomach pains, just weakness in general, brain fog, lack of concentration, weight loss, and many prescription adjustments as they're trying to find the correct drug cocktail that works now. The methotrexate that worked for many years to keep the GPA in remission obviously now can't be used because of the issue that it caused. Some surprises, fears, and takeaways that both Pat and I, on a personal and a professional level, have experienced. So Pat paid premiums for 30 years, LTD premiums, with the understanding that she was going to receive the benefit tax-free. She was told she had to apply for CPP disability coverage, which was very difficult because she was still suffering from the fatigue, brain fog, focus, everything. The provider offered no assistance other than you got to apply by this deadline. She was approved after a lengthy application process, and due to the process time, Pat owed the provider a substantial check for overpayments because during the whole application process, Pat was being paid by the provider, and then the overpayments had to go back to the provider. CPP was supposed to send that overpayment directly to the provider. They didn't. They sent it to Pat. So then Pat and myself, had to figure out how to get the money to the provider, and nobody was any help with that. Now the CPP payments are taxable, so about 50% of the benefit that Pat's receiving is taxed, and the other from the provider is not taxed. This, on a professional level, made me better aware of the CPP offset clause in any DI policy. I'm sure all of them have it. And I make sure I talk to my clients about that, especially when they're asking whether it should be taxable or non-taxable benefit. And the first year, Pat had to pay income tax because of the large amount payback that we had received from CPP, which was taxable and a lump sum. Because basically it was a complete year of back pay because we started the application process late January and we didn't receive the check till mid to late December. Some of the fears that Pat's still dealing with. She receives a letter confirming LTD payments annually, even though the doctors are saying she's never going back to work. But she lives in fear of receiving that letter. And she just told me just before we started this webinar that she just got confirmation that she's approved for another year. Um, we're waiting for, I'm sure one day the provider is going to offer a buyout proposal, and we're fearing having to deal slash fight with the provider to hash that out. Obviously, we're both concerned about having further health setbacks. It's obviously the money is one thing, but I want my wife here, so the health concerns are always at the back of our minds. Um, Covering the drug costs if benefits were removed. I'm hoping to retire in the relatively near future. So obviously I'm going to lose my benefits. Pat is on her, it's actually in tax benefits as we speak. And they have never said that they're taking her off. They just did a big plan redesign, and we had to um, navigate the high cost specialty drug that Pat's on. Even though the provider didn't change, we had to go through the whole pre-approval process again with the plan redesign change to make sure. And Pat just said we still don't have approval of the high cost drug that she's on. So we're waiting to hear that. It's $2,800 a month. What's the name of the drug? Nacala. Nacala is the name of the drug. And then if that's not approved, we're going to have to navigate the Trillium program. And in my experience, as I think most people, navigating anything the government does is never easy. Um, and then again, anxiety dealing with the provider when new drugs are prescribed. There was one drug that Pat was on. She was taking the generic drug. The doctor changed it to the brand name drug because it just we weren't seeing the effects of it. And that was a $50 cost that we didn't expect because we didn't complete the right papers to get the brand name versus the generic change. And I know I'm in the industry, but I guess I'm not very good at my personal side of it. And in just completing forms, everything. It's this process for LTD is incredibly labor intensive on the person that is making the claim. Luckily, Pat has had a supportive employer. I hope to think a supportive spouse, and also I'm lucky enough to have at a drop of a hat phone call any expert. Half of them are on this call that I could call and say, this is what's going on. What do you suggest? Also, Cowan has been a great resource for that as well. I couldn't imagine someone that didn't have a supportive employer, didn't have a supportive spouse, or is struggling with a mental health concern trying to navigate this process. It would just be a nightmare for them. So I don't know how we fix that. I understand there's a lot of fraud in the industry, especially on the disability side, but that doesn't help the people that actually need the disability um, coverage. A takeaways for me from the industry, I have lots of personal stories now that I can relate to my clients. That's why I'm doing this today. I hope you feel free to use our story with your clients, because it is hard. Like I just said, it's a labor intensive process. Um, and I'm honest with them. It's a bumpy road. I'm not going to sugarcoat it. I tell them I'm honest with my clients all the time. They know that. So when I tell them it's a bumpy road, they expect it's going to be a bumpy road. And again, if the employee's not supported by their spouse or their employer, it's going to be even harder for them to go through. And I scream it to all my account execs that this needs to be easier. For the people that need it. I understand there's fraud out there and they need to protect themselves and our clients at the end of the day against increasing rates, but something needs to be done. It's just not working. Thanks for listening to our LTD journey. if you have any clients in the same experience or position that I'm in, feel free to pass on my name, Pat's name. We'd be happy to talk to any of them. And I want to thank, there's lots of people on this call. I'm not going to name them for risk of missing someone, but there's lots of industry experts on this call at Cowan that I have leaned on for support, and I want to thank all of them. And again, if you need anything, feel free to reach out to us. The next page here. Oh, that's the end of the slide. I saw that had. Oh, there's the email. It's right there. Feel free to email. That's our personal email there. You probably, most of you have my work email. Feel free to reach out to us. If you know Lindsay or Blake, they can connect with me as well. And if you have any questions, I don't know, we have a couple minutes left now. Feel free to ask questions now, or if Lindsay says that's not allowed, we can do it at the end as well.
We're going to hold off till the end. But thank you so much, Rob and Pat, for sharing your journey, and also being willing to be a reach out or contact to anybody else currently going through it or knowing somebody that might need some assistance. So thank you.
All right. I'm trying to figure out how to stop sharing, Linz. How do I do that?
I'm not the most technical person in this room right now. I think go to the top, the top. Yep, you've got it.
I think Blake did it. Thanks, Blake.
I stopped it for you. No problem. Yeah, so thank you, Rob, for sharing that kind of very close, intimate story. That's quite the journey you've been through. And then we're delighted to have up next is Rinku from RBC Insurance. So RBC Insurance is an A-rated insurer with the largest block of individual disability insurance in Canada. They are also well known in the group benefit industry for the unique guaranteed standard issue GSI disability product. With such a large block, they process a lot of claims each year. We are thrilled to have Rinku Malhi, a senior manager in claims and customer experience here, to discuss both the RBC philosophy around claims, as well as some of the contract wording and the claims process. Thank you, Rinku, and welcome. I will share my screen for the presentation
Blake.
here.
Can you guys hear me okay?
Yep, you're good.
Awesome. Okay.
And so whenever you want me to go to the next slide right after the start sharing, just say next slide and I'll filter through them. We should be good to go.
Okay, great. Awesome. Thanks so much. Okay, great. We're running. So hi, everyone. Thank you so much for having RBC Claims team here today. My name is Rinku. Like Blake describes, my title is Senior Manager Claims Client Experience. Just a little about myself. So I have around 8 years of experience in banking, which includes 6 years of experience in the insurance industry at RBC Insurance. Almost 7. Time just flies, really. Before taking on this role and the claims client experience team, I was a claims specialist for about 2 years on the individual side. So I handled a lot of complex claims, and now coming into this team, I've really broadened my knowledge about like all of the insurance world pretty much. I'm very passionate about our clients and just advocating for them and the process excellence. My goal is to really continuously find better ways to assist our client, facilitate the claim process, and hopefully in the long run, just simplify the entire process and make it easy for them. My role in a gist of it is kind of to support our internal claims team and our external partners like our sales advisors, brokers, employers, or clients. You can really think of us like superheroes at times. You know, if you have a problem, you shine that light. And like Batman, we magically appear to save the day. So we're pretty much the buffer between the claims world and the outside world. And our goal is to really bridge that gap, ensure collaboration, ensure understanding, and get the client to, you know, get back into their normal, whatever form that may be. So we can start off and just go over our agenda today. So next slide. So we'll go over, so who's our claims team, who the players are when it comes to a claim. Then we'll jump into the philosophy, and then we'll go over the claim process and some of the key definitions. And we'll end it off with Q&A if it's going to happen right away or at a later time. That's all good. Next slide, please. So your disability claims team. It is very important to understand who the team is and who the key members are. and how everyone really comes together and plays a role in the claims process. So first off, you'll have your dedicated claim specialist. This is the person that is assigned to the claim and will be the main contact for the client and yourself, or whether it be the broker or the employer. The claim specialist is really the policy experts. They are the one who are going to advocate for your client. The claim specialists are also supported by many internal teams that are going to help them into managing that claim. So to start off, they're going to have the claims manager and the consultants. They're very knowledgeable. They're experts in claim management, and our claim specialists are always in good hands, and they can tap into their knowledge at any time. We also have our amazing vocational rehab team that intervene when our clients are ready for a return to work, or if they need a little assistance to help with their recovery. They can also help our clients connect with the right healthcare providers, like specialist psychologists, or the right psychiatrists, or the right physios, whatever the need may be for that specific employee or client. The medical jargon, clinical notes are never very easy to comprehend, especially if we have multiple diagnoses, different treatments involved, different tests being done. So to help with all this, all the understanding, our claim specialists are supported by registered nurses and medical experts that in different fields, like we have orthopedics, sports medicine, or mental health. Our disability team really comes together, they collaborate together, and they're going to work with the employer, with the brokers, to really, at the end of the day, have that same goal and help the client get back to doing what they love doing the most, and work, of course. So we understand our clients come to us when they're very vulnerable, and we really work tirelessly to ensure that all the avenues are being explored, and really ensuring that they're getting the appropriate treatment, and hopefully at a sooner date than later. Next slide, please. So our philosophy, our claims department adheres to a well-defined philosophy to guide its daily activities. It's an important component of our philosophy centers through the thorough, fair, and objective evaluations of claim to ensure that claims that are payable are being paid with the highest level of customer service. The claims department commits significant resources to ensuring effectiveness of the claims evaluation process as well. When appropriate, our goal is to help our clients return back to work by facilitating a safe and timely transition. This can also, like I said, be done with the help of our internal vocational rehab partners or external vendors that our rehab partners engage with. We have partners like Medical Confidence, like Medica, just really great partners that are going to help assist our clients with treatment, appropriate care, and helping with the return to work. And we do all this by really looking for innovative health solutions to help assist our clients with the recovery and ensure a more seamless process. We could go to the next slide. So long-term disability is something that you're already probably very familiar with. Long-term disability is an income replacement that may be payable after the elimination period once that's been met, normally on a monthly basis, and when the employee is basically unable to perform the duties of their occupation due to an injury or an illness. Next slide, please. So under the long-term disability, depending on the type of policy the employee may have, they can qualify for 3 different options. They will have total disability, partial disability, or residual disability, and I'll go into a little bit more detail in the next slide. And then there's also the pre-existing conditions, which may apply in long-term disability. We normally see those in pre-ex. With GSI or individual policies, we normally see a contestability, which is a different type of review.
Nice. It's okay.
The next slide, please. Thank you. So total disability normally is something we see often in policies, and this is probably the easiest one to explain. The employee is completely off. They're unable to perform any of their material and substantial duties They are not working in any capacity, not in their current job, not in any other occupation. Should this benefit be payable to age 65, they'll basically receive their full benefit amount. But some policies do also have that change of definition period. So what is change of definition? This is when a client is going to go from their own occupation to any occupation. Now, any occupation doesn't mean that we're going to tell a lawyer who earns $1 million a year to go work as a librarian. What we're really looking at is based on the ongoing restrictions and limitations and the employee's pre-disability earnings. Normally, we look at about 65% gainful. That's kind of the norm, but you may want to look at the policy just to see if there's a difference. And then we're going to look at their education, training, and experience. Would they be able to perform any other occupation based on this information? If the answer is yes, we have our amazing rehab team. Like I said, they're going to assist the employee with their job searches and any other activity that may help them really look for their other position if they want to. There are times where the employee might disagree with this decision, and if they disagree, they can appeal, and at that time, there'll be an independent review. If the change of definition says no, this employee would never be able to perform any other occupations based on their education, training, experience, and based on their gainfulness. At that time, basically the change of definition is accepted, and they're going to qualify most likely benefits on an ongoing basis, potentially to age 65. Now, what if the client is disabled, but they're able to perform their duties in some capacities? So this is when we have two other options. So we're going to have residual disability and partial. Our residual disability product is a premium definition, as it allows really the most flexibility to our plan members when they're able to work in some capacity, but still experiencing a level of disability. So this one really looks at earnings. Does the employee have a loss of more than 20% on a monthly basis? Versus partial, we're also looking at the duties. So there's at least one or more important duties that the employee is unable to do, and they have that loss of 20%. So residual, we're not really looking at earnings. We're not really looking at the duties, just at do they have a loss of earning. In my experience so far, I've really mainly seen the total and residual disability. I haven't seen partial so much. Yeah. So now we can go on to the next slide. So when it comes to return to work, this is really when the benefit at times may be even more important to kind of cover that gap in the salary being paid by the employer. So the employee is doing their best to return to work. And if the policy doesn't allow for some of that ongoing benefit, this can be an added stressor. It can cause some additional financial stressors, which at time may hinder that return to work or may force the employee to go faster than they should, which may lead to recurrence. Sometimes everything goes well, but sometimes it does lead to recurrence if they go too fast. Under residual disability, you can see that if an employee continued to do some of their duties but wasn't working, let's say 2 days out of 5, the elimination period accrues. And then when it comes to gradual return to work, benefits are going to remain payable until they complete and get, until they still have that 20% loss of earnings. Under partial disability, the same thing. So here at the second, the middle one, you could see so in the beginning, it seems like the employee was on a total disability. And then during the gradual return to work, they're working 3 days out of 5. So we'd be able to continue paying benefits during that period to support them during their gradual return to work. But when it comes to total disability, because they no longer are totally disabled during that gradual return to work period, unfortunately, they would no longer qualify for benefits and the claim would close on our end. We do have our rehab programs, like I said, so if there's a complex return to work, sometimes they will provide that additional assistance when they can. But if it's a simple return to work, sometimes it's not really needed. in that kind of case, the claim would be closing. So now you can really see how having that residual or partial disability can provide that additional support to the employee when they're attempting a return to work. You can go to the next slide. Awesome. So just a few contractual provisions that I'll go over. The pre-ex, like I mentioned, this is when an employee goes on leave between, like, first, basically they've just been hired and they go on a leave of absence within normally a 12-month period from their date of hire. So due to privacy breach reasons, we normally at RBC Insurance, we call this a contractual review. So in such a case, we need to request additional medical information from their pre-date hire, normally a max of 3 months. Should the employee have had any symptoms or treatments related to the same condition that they are now on a leave of absence for, unfortunately, the claim will be denied due to this pre-existing clause. So it's important to just look at the employee's contract to determine when that period falls in, as they may be one of the reasons why it's denied. Then we have the 3-month survivor benefit. So this is a lump sum that would be payable should the employee pass away when they are on an approved claim. So benefits are normally payable to the beneficiary that is designated, or if there's no beneficiary, then it's going to be issued to the estate. COLA, this is the cost of living adjustment. So this is an index percentage of normally the CPI rate to keep pace with the inflation. So every year on a 12-month basis, if the claim continues to be approved, the employee would receive an increased benefit with regards to that portion. I think over the last few years with the inflation, it's been fairly high. So I think it was at 6%. But it really depends year over year on what it's going to be. Rehab and return to work assistance benefits is probably, like I said, one of the most important things to help the employee with their gradual return to work. And at times, depending on their policy, it may provide an additional 10% of their gross disability benefit, which is always nice. It just helps the employee with their return to work as well. Dependent care expense benefit provides a reimbursement for all expenses incurred to provide just that personal care to a dependent. Disability conversion, let's say an employee is deciding to leave their employer or they're terminated, it really allows them to keep their coverage. So they can convert their LTD coverage for their long-term disability coverage into an individual policy. Which I think is a very nice to have, especially if someone's not going to be employed for a few months. And finally, you have the spousal disability benefit. It would be like coverage for, it's pretty much like a long-term disability coverage, but for their spouse. Okay, now we can go on to the next slide. So now the important stuff. So how to really be there and understand the claims process to guide the employee. If the client has a short-term disability with RBCI, we normally don't require the client statement or the attending physician statement for the transfer, so for it to go from STD to LTD. However, if the client doesn't have short-term with us, to initiate the claim, we're going to require that client statement, the authorization, and the attending physician statement. If their STD provider recently requested an attending physician statement in the last 6 months, we can accept that as well on our end. So they don't need to go back to their treatment provider and have another one completed. And pay for another one, of course. So unfortunately, RBC does not cover the cost of the attending physician statement, but there's a little hack to this. If the employee provides medical from the onset of their symptoms alongside the attending physician statement, or even some medical, sometimes the physician is going to provide only one medical receipt. The employee can provide that receipt to us and we're able to cover the cost for that. So just a little hack if you want to share that. Then once the claim forms are received, the LTD and GCI process for some who may have an individual policy as on top of their long-term disability process is very similar. So the disability claim specialist, as part of the initial review, will review all the information that's already on file. They're going to determine if additional information is required to make a decision on the claim within 10 business days. If so, they're going to make the request for the missing information and they will likely pend the claim. Should there be sufficient information, so let's say the employee did provide all the medical upfront, the claim specialist can conduct a quick clinical review, so with our clinical partners, and perhaps provide a decision to approve and then determine if additional information is required. A key difference between the long-term disability and short-term disability is that benefits are now issued on a monthly basis and in arrears, and this can sometimes cause a bit of a financial stressors on the employee. So we do try to really, do the process as quickly as we can. So when a claim is approved during the ongoing management, the claim specialist will request additional medical as necessary and continue to assess the client's condition with the help of our internal partners or with the added value services that we provide. Should the initial claim decision be pending? So a claim can be pending for many reasons, such as the need of updated medical information or any type of financial documentation for proof of employment, for example. If a claim is pending, the claim professional is going to do a follow-up every 30 days to advise the status of the claim. This update is provided to the employee and the employer. Employer, of course, will receive a redacted copy, just removing all the privacy information that may be related to the treatment provider's names. And then we're going to provide a decision as soon as it's available. If the claim is unfortunately denied, it's really important to understand why, so that it's really important to understand the reason and the why behind the denial. The decision will be communicated to the employer or the broker first on the file to ensure that they're aware. And then if the client does call them, they're able to just give them a bit of guidance on that piece. All parties involved will be provided with an explanation of appeal, but of course for the employer, we can't really give them full details on why the claim is being denied, because a lot of it can be related to medical pieces and just might cause a privacy breach there. But the employee would receive a very detailed letter explaining why the claim decision is denied. So for the appeals process, the client must submit a written explanation on why they disagree with the decision that's made and provide additional medical or financial, depending on the reason of the denial, to support their appeal. Once this information is received and we receive their letter of intent for appeal, it's going to be transferred to that different unit and they will do a follow-up every 30 days until a decision is made. If appropriate, so let's say a claim was approved, they're doing ongoing management. Once we do have an anticipated return to work, the claim specialist at that time, that's when they would connect with our vocational rehab team when appropriate. And if there's simple return to work, as I mentioned before, sometimes it's not very necessary. Finally, there are some unfortunate cases where the client is not expected to recover. They really won't be able to go back to their pre-disability occupation or pre-disability earnings should they have met this change of definition. In that case, it's possible we advise the clients to apply for CPP if that's applicable to them, and the claim is going to be transferred to the extended duration unit. In such cases, then the claim is going to be assigned to a new claim specialist, and normally there's only going to be yearly touch points at that time, just to ensure that there hasn't been any changes over the last year. And yeah, that's all I have. Next slide is questions.
Wonderful. Yeah, I think we'll hold all the questions till the very end if you're okay to stay on, and that way we've got everyone there. But Thank you very much, Rink. When we were first putting this together, I thought it was going to be a bit difficult getting someone from claims to really come on and share. And the first company I reached out to was RBC, and RBC was all over it. So a huge thank to both you, Rinku, and RBC Insurance for stepping up and sharing that. That's excellent.
Yeah, my pleasure. It's great being here. Thank you so much.
Wonderful, great. And our last speaker is David Scher. So David Scher is the president and managing director and co-founder of Scher Lawyers. David's practice is devoted to disability insurance litigation, and he represents disabled clients with compassion and sensitivity. David has been practicing law since 1985. He is a member of both the Ontario and New York bars. He is very well respected within the legal community, has spoken at many conferences, been interviewed in the media, and is often called upon by his colleagues within the legal profession for his experience and knowledge in this practice area. David's also served as an adjunct professor at the Osgoode Hall Law School in the trial advocacy course for 12 years and is an active member of many associations, including the Law Society of Ontario, the Advocate Society, the Ontario Trials Lawyer Association, and the American Association of Justice. David has an extensive experience in settlement negotiation of disability insurance claims, as well as mediations, arbitrations, and trials. As president and managing director, he oversees the progress of each firm's cases and provides input and seasoned counsel to the firm's lawyers. Clients can rest assured that David's experience is at work for them. David's also passionate about music, and as a child, he considered a career as a musician, and he also enjoys playing tennis and spending time with his grandchildren. And on a personal note, I've seen David speak at a few different conferences, and he's always been very generous with his time to this industry. So I just also want to just personally thank you, David, for kind of just helping everybody be better in this industry with your time. So go ahead and take it away.
Okay, well, I guess the first thing I ought to do is get up the, can everyone see that okay? I guess if I don't hear otherwise, I will assume it's fine.
You can see it
Yeah,
now.
you're perfect.
Okay. So the title of my little presentation is LTD Claims Gone Wrong. The focus of this, just hold on a second. I don't know why it's not moving here. There we go. I'm going to focus on pre-claim issues and then litigation, but and I guess there might be some overlap with some of the other speakers, but I want to talk a little bit about enrollment of employees into a group benefit plan, the annual updates regarding the insured's salary or income, non-evidence limit, a bit of a bugbear in terms of cases that we see from time to time about that issue. Transition from insurer to a new insurer. I think I commented on somebody had a question about, switching from one insurer to another and what happens with the pre-X. So we can talk a little bit about that, and the effective date of coverage. So then we'll get into some litigation issues, and I'm going to keep mindful of time, so I'm going to try and keep this moving fairly quickly, and I'm happy to take questions at the end or afterwards if you circulate my contact details and anyone wants to ask me more detail on any of these things, please reach out. I'd be happy to do that. All right, so the first point, and I guess it sounds obvious, but ensure that employees are enrolled promptly as of the appropriate date of coverage, making sure it's in place in accordance with the employment contract or office policy. Someone was just telling me a few minutes ago before I came on to this conference that someone is having their claim reviewed for a pre-X exclusion, but the 13 continuous weeks of employment got delayed because the employer was late by a month in getting this person enrolled. And that can have an impact in terms of whether they're going to qualify for LTD benefits at all because of the pre-X. Pre-X cases can be complicated for a whole host of reasons, but if the enrollment is off, then that can expose usually the employer for a negligent administration claim. So as I mentioned here, there's a possibility of an uninsured claim, and the employee becomes disabled prior to the coverage being placed, but within the date when it should have been in effect. And of course, I mentioned this already, the delayed running of the pre-existing exclusion period. The example being someone gets disabled within 18 months of an effective coverage date, but coverage, if it's delayed by say 6 months or greater, that would allow the insurer just to look at a pre-existing exclusion that might not otherwise have applied at all. In terms of the annual updates of salary or income, this is something that when you're speaking with your group clients, the administrators or the HR or whoever's looking after these things internally, that they need to be reminded that, when you're doing your annual increases or reviews of salary, to ensure that if the policy is supposed to insure them for their base salary, it should be the accurate base salary, because many group plans have a provision saying the LTD benefit will be the lesser of whatever the formula is on the salary or what they paid premiums on. And so in this example that I've got here, someone was being paid $35,000 when they were hired, and the enrollment was based on that salary. 5 years into their employment, they made a claim. They were around 40 years old at the time. The employer had failed to update the salary. By the time this person went off on claim, the salary was $50,000, and the benefit at 60% of base salary would have been $1,750, but at $50,000 would be $2,500, and that is an under insurance issue. And as I mentioned, the policy said coverage is for the lesser of actual income or reported income. In this case, the shortfall of $750 a month could translate into $9,000 a year. And if this person is on claim for 25 years, potentially, it could be looking at damages of $150,000 plus for that underpayment. This is a case similar to a case that we were actually involved in. What was interesting about that case is that the increase in salary came as a result of a retroactive adjustment through a labor relations union situation. And so there was this was a very large institutional employer that was ordered to comply with this, but then they didn't do anything to update their administration for their employees. So this person kind of fell through the cracks. Non-evidence limit, I mentioned this as a bugbear. What I find is that very often employees will be given some sort of booklet or summary of coverage, and it might say in it that there's a non-evidence limit. The coverage is, non-evidence limit of $5,000, say, but there's coverage up to $15,000, and that's all it really says. And if the employer doesn't offer the evidence of insurability forms to the employee at the time of enrollment, then that individual is going to lose out. And what I find with employees when they contact us about this issue is they usually are very poor historians about all of this. When they're signing up or getting a new job, they're focusing on their new job. They want to know that they have benefits, but they're not really drilling down into the details. And most of them say, what is this non-evidence limit? I had no idea. I thought I had $15,000 of coverage based on my income. And it becomes a he said, she said type of a legal case, because if you've got the right paper trail or email trail or digital trail showing that this information was provided and the employee was provided with appropriate information to fill in the evidence of insurability form, then you should be okay. But in some cases, that records aren't kept very well, and it becomes a real problem. So we've had a couple of cases where we bring in the employer into the lawsuit and make our efforts to try and bridge the gap between the non-evidence maximum and what they could have received if they had been given the proper opportunity to complete those forms. So changing insurers, the issue there is ensuring the proper handoff. Failure to do this properly can expose brokers and employers to liability as well. If you're this can arise in a merger or sale of a company where the new acquiring company is providing a different benefit plan, and you want to make sure that you're grandfathering people in who've already got proper coverage in one company, if that's the intention of the agreement. If it isn't, obviously employees are going to have to be properly advised. The other situation, of course, is that on renewal of the group benefits, you can get a better quote from insurer A as opposed to the existing insurer B, and you want to switch because it seems like a better deal for your client, but you got to make sure that the new insurer is prepared to recognize and deal properly with grandfathering employees who have already been with the company for an extensive period of time, so that they're not having to deal with a pre-existing exclusion because they've only had coverage as of the date of the new policy being issued. All right, so now I'm going to switch gears a little bit and move into what I call post-claim issues. And the lineup is the plan sponsor statement and the employer statement when you're filling in the original application, the situation with dealing with a workers' compensation claim, what to do in terms of dealing with short-term disability claims denied by an insurer or a third-party administrator. They can be a little complicating in terms of making sure that an LTD application gets submitted. And then claims arising at employment termination, were they actively at work, were they not actively at work, and that whole question of coverage. And then back down, big topic of employers being added as defendants because of some problem with what happened with the LTD coverage. So on the plan sponsor statement, it's important to provide an accurate and timely completion of the LTD forms and provide those forms when an employee has been in a disability claim or it says that they are disabled, to provide the forms. Again, I mentioned again here the accuracy of salary information. The question is, if you learn about it at the time the claim is being made, is it too late to rectify the failure to update the income? It may be, but if you learn of it, it's still better to do it than after a claim has been approved for a lower amount. And depending on the relationship of the employer with the insurance company and how big a client they are, insurance companies may sometimes rectify that problem if they consider the employer to be an important client. So on termination of employment, it's important that the client consults with an employment lawyer regarding the treatment of an employee on disability and what happens in the event that an employee is putting in a claim on termination. So they learn that they've been terminated or being terminated, and they say, well, okay, I'm going to go on disability. Some employers in those circumstances might say, what are you talking about? You're no longer covered for LTD. You've been terminated. I'm not giving you the forms. And my advice, and I think this is what you should share with your employer clients, is give the forms. If they say that they're going to make a claim, I mean, it sounds like, a no-brainer, but just give them the forms. You have the insurance. You may not really want to claim. You don't want to, it's going to affect your premium payment history and all of that, but failure to give the forms and then the employee has a valid LTD claim or an SDD claim can, be a problem that will end up creating liability for the employer. And let the insurer and let the third-party administrator, if there is one, decide on whether they're entitled or not. It's not the role of the employer to make a determination, or the broker for that matter, to make a determination about whether the person qualifies for that benefit or not. If they had coverage as of the effective date, then allow them to make the claim. And the last point here about maintaining coverage during a notice period and to advise the insurer, this continues to be a difficult area because many insurers are not prepared to extend coverage into a notice period. And I, as a group who does this type of work, I suggest you keep leaning on the customers, the companies you do business with to say, is there some way we can alleviate this issue so that the employer has been able to extend LTD benefits during a notice period? Because the case law suggests that if someone is terminated today and 3 weeks from now gets disabled and their coverage was terminated, they may be entitled to that coverage during the notice period. And if it's not there, then their claim turns into a claim against the employer. And I'm sure that many of you are already familiar with this case. It's not a new case, Brito versus Canak Kitchens from 2011, and then went to the Court of Appeal in 2012. It is still good law in Ontario. I suggest it's probably good law in other provinces as well. I noted it up today just to see if it has been overturned. It has not been overturned. And it seems like an unusual set of circumstances, but these unusual set of circumstances are often the types of cases that make the law, and then we're stuck with these situations for better or for worse. So in this case, for those that aren't familiar with the case, Mr. Brito was dismissed without cause. He was 55 years old, having worked at Canak Kitchens from 1979 to 2003. He received the statutory minimum payout after nearly 24 years of service. He hired a lawyer, obviously, to pursue his claim. The employer, it was noted in the decision, had a history of litigating employment disputes. So that they had a pattern of not settling these claims, but rather taking them through various stages in the litigation, and presumably all the way to trial in many circumstances. Brito did find other employment at a lower rate of pay, and his medical history showed that he had had multiple surgeries for laryngeal cancer in 04, 08, and 09. So, on the face of it, it looks like, well, he's no longer employed by Canak after 2003. How can he possibly be entitled to any LTD coverage? But the fact that his illness commenced in 2004, the common law notice period for a case like this is probably 24 months. So that would take you into sometime in 2005, his claim arising, and he did not have LTD coverage with his new employer. Claim was denied. He consulted a lawyer. They made their initial notice of claim. He started the lawsuit, served it on all the parties. Affidavits of documents or records were exchanged. So for those that don't know what that is, it's just the listing of all the relevant documents that is required to be exchanged. Discovery or questioning, depending on which province you happen to be in Ontario, examinations for discovery are where you, in the olden days, would go to a court reporter's office and be questioned by opposing counsel. These days, it's mostly done like we're doing here right now on Zoom. And there's a court reporter recording it all down. And the similar opportunity is presented to both sides to do that type of questioning. So when the questioning of the defendant occurs, in the case of Canak, it would have been perhaps the HR representative that was examined, or someone more senior in the company. And with respect to an insurance company, it's usually either the senior claims analyst, or it's the person that was most responsible for adjudicating the claim and denying the claim. And then very often there will be either a defense medical or a plaintiff medical or independent medical assessments that are arranged, and other expert assessments that are arranged to assess the medical evidence in the case and provide opinions regarding how disabled the person is. And then very often at various stages, this can either be before discovery, after discovery, before or after these medical assessments occur. There can be a mediation or a settlement meeting, or offers can be exchanged to try and settle the case. The vast majority of disability cases are settled either on a lump sum basis or reinstatement. I would say the majority are settled on a lump sum basis rather than on reinstatement, but it depends on the case, and it depends on what's being offered and what makes the most sense. The reason I say that in most cases it's a lump sum is that the vast majority of people that have been involved in a claim that's been denied would prefer to have a one-time payment and not have to worry about dealing with the insurance company again. And the insurance companies are also looking for closure and to move on from a claim. And so I would say most insurance companies favor the idea of a lump sum settlement. That doesn't mean that reinstatement doesn't occur. And if the matter proceeds to trial, then the judge cannot order a lump sum resolution of the claim unless the person's already at the maximum age for the benefits. In other words, if by the time the case goes to trial, the person's 65 or older, depending on the end time for the benefit. And I heard earlier that someone was being approved to age 75, which can happen depending on the policy in question. But those are the only circumstances in which a judge or a jury, for that matter, can order a lump sum resolution of the claim. If all of those steps still haven't resulted in the case settling, then there's a pretrial conference. A pretrial conference is with a judge. Further documents prepared to summarize where the case is, and orders can be made at that time regarding how the trial itself will proceed, the number of witnesses, things of that nature. But very often, our legal system is geared towards trying to get cases settled at the pretrials, because if you pay any attention to anything about our justice system, whether it's criminal law or civil law, there aren't enough courtrooms, there aren't enough judges to try every case. And so the settlement or resolution of claims is the only way the wheels of justice keep turning. So last, if it proceeds to trial, whether it's jury or non-jury, I'm going to talk a little bit about that when it comes to this Baker and Blue Cross case that people have heard about. That I'll come to that in a moment. The Baker case was a jury trial, and there's been a lot of debate about that amongst the lawyers that do this type of work, because generally speaking, most disability claims do not have a jury, and historically wouldn't have a jury because you're seeking what is sometimes referred to as declaratory relief. In other words, you're asking the court to declare that the person is entitled to benefits and is disabled under the terms of the policy, rather than giving a judgment, an award of damages. All right, so carrying on from here, how are we doing for time so far? Are we okay?
Yeah, we're very good.
Okay. I'm trying to move on. Let's see. There we go. So back to the Canuck case. They had provided 8 weeks of disability coverage upon dismissal, which is in accordance with the Employment Standards Act minimums. And that he did not have, as I said earlier, he did not have LTD coverage. The case also dealt with with severance and the notice requirements, so you can read about that if that's of interest to you. Canuck, no insurer, Canuck was found liable to provide damages in lieu of the short-term disability and long-term disability benefits to age 65 for Mr. Brito by way of a lump sum award. This is unusual. This is something that, as I said, can't happen in an LTD case, but because Canuck is not an insurer and in no position to essentially adjudicate an ongoing claim, and clearly the relationship between Canuck and Brito would have been a prescription for disaster. So they awarded a lump sum of all benefits owing. I mean, what isn't clear to me, and I still don't really know the answer to this, is whether Mr. Brito actually lived to age 65, because that would have been an overcompensated amount if that were the case. And that's one of the reasons why lump sums are usually reduced to some extent to allow for things like life expectancy or mortality. There were $15,000 in ancillary damages for things like mental distress caused by the hardball approach that Canuck took. And in addition to the damages, there were costs of $125,000 awarded. At the Court of Appeal, the main award was upheld. The $15,000 amount was overturned. This case, which is a newer case from Saskatchewan called PASAP versus the Saskatchewan Indian Gaming Authority, is a wrongful dismissal case, but there was an entitlement to a disability allowance, and there were damages awarded for loss of disability benefits. So this is a newer case. 4 months in notice. 4 months into the notice period, Mr. Passup suffered a catastrophic medical event. He suffered with congestive heart failure, intermittent episodes of flash pulmonary edema, and an inability to wean off a ventilator. He had reduced mental ability, poor cognitive function. He tried to return to work after 2 years and had a little bit of income, but which was much lower than what he had previously earned. Couldn't hold down a job, which knocked out the any occupation test. So what I mean by that is he couldn't earn enough to bring it up to a commensurate level as defined in the benefit plan. There was a 24-month own occupation period. The court found he was totally disabled within the meaning of the plan. He was found to be totally disabled during the 24-month own occupation period. He was awarded also on a lump sum basis $1.2 million, which included arrears and the present value of future LTD benefits to age 65. He got $25,000 in moral damages for bad faith and $25,000 in punitive damages for them fabricating the reason the plaintiff left his employment and maintaining that position for close to 10 years. You could read more about the case, but there were some shenanigans going on there about trying to make up the reason why he left, which was completely false. Before I come to Baker, I just want to say I did check again this morning on this one, and there does appear to have been a notice of appeal filed to take it to the Saskatchewan Court of Appeal. That was back in 2022. I could find no record of any decision having been rendered yet by the Saskatchewan Court of Appeal. So I don't know if that means the matter has been dropped or there is actually an appeal proceeding. But again, this is obviously troubling to those people that are on the other side of these cases if this stands, and we'll see if it gets reduced at some point. But a lot of the same factors that you see in Brito are here. Baker, I imagine many of you have seen a news item about this. So this jury verdict came down in June of 2022, and the entire case, save for a couple of reasons for how they reached the decision, was upheld by the Ontario Court of Appeal just this past December. It was a 5-week jury trial, which is very unusual in long-term disability cases. At the end of it, the benefits were reinstated or approved. So Ms. Baker has received her benefits ongoing as of the trial and ongoing. There were $40,000 in aggravated damages. There was $1.5 million in punitive damages. What I haven't put in a bullet point here, which has been upheld, I believe, by the Court of Appeal, is the cost award. The amount of legal costs that were awarded against Blue Cross was in excess of $1 million. They wanted to ensure that this plaintiff was 100% made whole. In other words, after paying their legal expenses, which may have turned out to be less than $1 million, depending on how the firm that was representing Ms. Baker gets paid. They wanted her to not be out of pocket $1, and the Court of Appeal seems to have gone along with that, but for slightly different reasons than the decision made by the judge at the trial. Blue Cross ordered and obtained 375 hours of surveillance. That's a lot of surveillance. That's 15 full days. Very expensive to do that. You don't see that. I've seen cases where surveillance has been conducted on 3 or 4 separate occasions over the course of a couple of years, 2, 3 years, but this is an awful lot of surveillance. So what did Miss Baker, what was the injury or illness? She had a brain bleed, suffered a stroke at the age of 47. He worked as a hospital director at Humber River Regional Hospital, which is at the 401 and Keele in Toronto. Blue Cross said she could work in an alternative occupation as a dietitian. I don't think she had any particular credentials as a dietitian. Blue Cross developed what was described as an animus towards Ms. Baker. In other words, they really did not like her. And in particular, the lawyer that represented Blue Cross, who I won't mention the name, but you can look it up, we've had cases where he does tend to get pretty personal about his cross-examination or examination of the plaintiff. That's a style that I guess has been very effective for him over the years. Blue Cross ignored their own guidelines regarding the duration of the disability. In other words, there was some evidence to suggest that they knew that she would be disabled for a period longer than they were prepared to recognize, even though their guidelines suggested that she would be off for a longer period than that's what they were prepared to pay her for. They were focusing on the lack of objective proof, and that most of her complaints were subjective, which is a theme that we see in insurance cases, whether it's disability or personal injury. You know, what is real, what isn't real, how do you prove it? It's always a challenge. It's a big challenge for plaintiffs, and it's a big challenge for insurance companies, because if you can't see it and you can't understand it, you know, what do you do with it? I think that we'll come back to the jury thing in a minute, but I think the counsel for Blue Cross here thought that the jury would not be sympathetic to Miss Baker. There was no doubt, though, in a case like this with a brain bleed, that there was objective evidence of the damage to her brain. The medical records were clear on the point. There was a wealth of documented objective evidence about. It's not a case where you can't see it on an X-ray or an MRI. There was documented changes that resulted in restrictions and limitations. This next point, that Blue Cross spent 5.5 days cross-examining the plaintiff. That's a very lengthy amount of cross-examination. And what I learned from teaching 12 years of advocacy at Osgood is that cross-examination generally, you know, it's quite the art, and you got to have a real plan. And 5.5 days of cross-examining suggests that it was just beating up on the plaintiff rather than having a deliberate plan of attack about particular points that they wanted to discredit her on. It's way too long a time. I know this from the lawyer that was involved in the case, that surveillance was being shown to the jury. There were 7 minutes of the video showing Ms. Baker having ice cream with her children on a park bench. And the lawyer told me that when, you know, you don't know how to read a jury, but he noticed quite a few people on the jury kind of rolling their eyes while they were watching this particular surveillance being played back, like, you know, give me a break type of thing. Now that he doesn't know for sure what they were thinking, but that, I guess that's what he was thinking while he was watching it. So actually, before I go to the next case, I guess we still have a few minutes. The whole question about the jury, it's very interesting in this particular case because of the pandemic. This case went on for many years and would have gone on for many years irrespective of the pandemic. But because of that, and the fact that Blue Cross was seeking a jury on this, the lawyers for Baker brought a motion to strike the jury, which was rejected. The court said, no, if Blue Cross wants a jury, they can have a jury. But the question now following this is that, you know, was that the right move by Blue Cross? Juries have been known to be fatigued by plaintiff personal injury lawyers advertising on buses and benches, and, you know, sort of becoming a little nerd to the whole idea of people getting their rights through the courts. But there's one thing about this type of a case: the defendant is a big insurance company. It's not Miss Smith who was, you know, riding her car down the road and rear-ended somebody. It's a little different. And so I don't know. I think we're still seeing jury notices on Blue Cross cases. And I will say this, that in spite of the decision by the Court of Appeal, I have no doubt that leave is being sought to take this to the Supreme Court of Canada. I don't know where that's at right now. It was only December, so we probably won't hear for a few months whether the Supreme Court of Canada will even hear this and on what grounds that are being appealed. They're not appealing the fact that she's disabled. The only thing that they were appealing at the Court of Appeal was the damage award and the costs. So we'll see what happens with that. One other case going back to 2018, you may or may not be familiar with the McIver and Pitney Bowes case. It's another case involving the notice period, someone being injured at a company event in Costa Rica. Mr. McIver resigned from Pitney Bowes in August of 2008. He was paid by Samsung for a period of time after that. In other words, he found a job at Samsung for a period of time after that. He brought the lawsuit in 2011. Manulife denied coverage based on policy wording that coverage would terminate on the earlier of the last day of the month in which contributions had been made or the last day he was actively employed. And the trial judge agreed with Manulife's position. But the Court of Appeal reversed that. They found that he was disabled pre-resignation and that he was unaware of the seriousness of his brain injury and its permanence. His brief employment at Samsung terminated in 2009. He attempted to claim LTD benefits through them, but as the injury occurred while working for Pitney Bowes, they took the position that claims should go through the Pitney Bowes policy with Manulife. There was an agreed statement of facts here that he was in fact disabled, and the Court of Appeal interpreted the policy wording in favor of the plaintiff. The termination of coverage wording only referred to future claims. In other words, if because this claim arose while he was still an employee of Pitney Bowes, then it didn't apply. If he had been terminated and then had a claim for medical condition or whatever that arose after that, then they would have found that he wasn't entitled to a claim. The proof of claim here obviously didn't occur within 90 days of his disability, but the court granted relief from forfeiture, which allowed the claim to go forward. That's essentially relief from forfeiture can be granted if it's not a substantive deadline, like a limitation period. It's more of a technical requirement to get a proof of claim in within a specified period of time. So that's the end of my my slides, and happy to take. I think you said something about leaving any questions to the end. So I guess as I'm the last speaker, this is the end. So if anybody has any questions, I'll turn it back to Blake.
Yep. No, thank you very much, David, for that excellent presentation. That was definitely interesting, especially with some of the newer cases and lawsuits. So what we'll do first is we'll pass things over to Lindsay, who's gone through the chat, and she'll go through any questions that have been in the chat. And then if you have any questions you want to ask live, we'll just ask that you raise your hand and we'll just go in queue. And lastly, if you have a question that you want to ask and you're a little bit too embarrassed to, just send Lindsay a private message and she'll happily read it without naming you if you've got a question but don't want to be put on the spot. And please go ahead, Lindsay.
Thanks, Blake. So the first question's for RBC, and it was one of the participants asking that you repeat the hack. Is Rinku still on, Blake? If not, I can reach out.
Sorry, Lindsay, is it Lyra here?
Hi.
Hi. Sorry, what was the question? Because I know Rinku had to jump out the meeting. She had something.
That's okay, Aldira. She just wanted her to repeat the hack that she mentioned during the presentation.
Okay, then I can. I'll take that back and let her know.
And you can just send it to Blake and then we can give it to the group.
Yes.
Okay, perfect. Thank you. Yeah. That's perfect. And then another one for RBC, but David did answer it through the chat. Was if a group moves from another insurer to RBC, would pre-ex be based on employee's initial effective date with the previous insurer? And David mentioned if it's done properly, pre-ex should run from the original effective date and not to the transition date.
That is correct. And that's where we ask for the prior bill to make sure that we honor and grandfather all the coverages. So yes, that's the correct answer. And the pre-existing condition, I saw a question too. I don't know if I'm jumping ahead.
No, that's fine.
It goes back. Yeah, it's like based on the effective date. and not the hire date. Now could be some confusion because there's the waiting period, and if an employee waives the waiting period, so we always go back based on the original effective date.
Okay, thank you. And then another participant said to you, David, can you define done properly?
Define what, sorry?
So you said if done properly, the preact should run from the original effective date, not the transition date. And the participant just said, could you define done properly?
Yeah, done properly simply means, I think it's similar to what, is it Sula or is Sula your first name? Adlira, okay. Is what about both the broker and the insurer making sure that there's appropriate language in the policy that honors the list of already covered employees that are coming over from the transfer from one insurer to another. And if that's documented properly, then there shouldn't be any issues about that. That's what I meant by done properly.
Perfect.
And I'll jump in too with all the brokers on the call, is that should be part of your process when you're moving a group, is to compare the old bill to the new bill and make sure all of the amounts are correct. That should just be part of a moving group process.
And something as well that from my experience we notice is the provisions of the contract in terms of, because each carrier has a different language probably in terms of the leave of absence or the definition of disability. So that's why it's very important to compare and make sure that that's the same wording.
Right. Thanks, Adlira. So David, the next couple of questions are for you. So the first one is there a standard time limit for a plan member to file an LTD claim from their date of disability? And if so, does it differ from the time limit in the insurance contract? Which time limit supersedes?
Well, that's a bit of a loaded question, but because it depends on which province. Let's talk about Ontario, because I think most of your members are from Ontario. So the Limitations Act says it's 2 years from the date that benefits were due to be paid, or technically 2 years from the date that a denial occurs. If you're talking about limits in terms of filling out forms, that's a whole different thing that's set out in the contract. But if you're talking about the drop dead time that the claim would be contractually or statute barred, the effective is 2 years. And what the real question is, when does the 2 years get calculated from? That you have to be careful about. But it's generally 2 years from the date that benefits were due.
David, sorry, Carrie here. This was my question. And just to clarify, this is an employee in BC, and the reference would be what is the time limit for them to submit their claimant form from the date of disability?
Yeah, so that is dependent on the contract. The policy should stipulate whether it's 30 days, 90 days, some other time frame. There is usually a time frame. And that, when I talked about relief from forfeiture, that, like, if someone gets it in on the 120th day, provided that there's sufficient reason, they may still get a denial from an insurer if it's out of time. But that is the type of thing that can be challenged based on the relief from forfeiture. The other type of deadline that I was talking about, 2 years, which, by the way, 2 years is generally the same deadline in British Columbia as well, is the statute of limitations. So, but yeah, go by the contract, and each group contract may have slightly different, like each insurer has slightly different approaches to that.
Thank you.
The next question was, is it necessary to offer the access amount EOI forms annually?
Is it a good idea to offer them annually?
Or
I don't
necessary?
think. I think that. Sorry, so much just came into my mouth. I think the answer to that is that's something that each company can decide upon, whether you're obligated to do that or not. I mean, I don't think it's a bad idea necessarily. I'm trying to think back on whether we do that even in our own firm. I think you're obligated to do it certainly at the beginning of the employment. And perhaps if there's a reminder that goes around on an annual basis, but you're not generally, I don't think, I could be wrong about this, maybe most of you people know more about this than I do, but I don't think there's usually a requirement to annually re-enroll people. There is an obviously an obligation to update salary information and check back in with people that way. But once you're enrolled, you're enrolled. So I think that's a matter of choice and something to talk about with the broker in terms of cost and I guess evolving case law in that area. I haven't seen a case that talks about an annual obligation. So legally, I can't say there's an obligation to do it annually.
Okay, thanks, David. The next question is, if a plan has LTD but is non-mandatory and an employee refuses benefits and signs off, is there still a risk for the employer if the employee becomes disabled? And does a signed letter by the employee protect the employer for a mandatory plan?
Is that directed at me or somebody else?
I'm sure it's at you.
Believe it was at you.
I think that that you should be okay if someone signs off on it and refuses it. If it's not a mandatory plan, then it's optional, and you should be okay. Just make sure you keep that on file and know where it is in the event that something comes up. And I mean, if you're concerned about it, at the time that they sign off on it, you might want to say to them, if you ever wish to revisit this, please notify us on some basis or another, something like that, so that they say, well, you never told me that I could still get it, like a once only. I think it's something that you might want to revisit at time of annual review or something of that nature, or when the plan is being renewed for the coming year. That might be something to revisit with employees, because let's say you're talking about a 20-something employee who says, I don't need that coverage, I'm fine, and then they're employed with you for 10, 15 years and they forget about it. I think that might be a good idea to bring up with them again at some point. But I do think getting a sign off will be helpful to avoid liability.
Perfect, thanks. The next question for you is, does an employer have an obligation to increase the NEM if it's offered by the insurer? In other words, is there any liability on the employer if they decide not to increase the NEM?
If the insurer gets an evidence of insurability form and then they're denied, is that what you're asking?
Can I jump in?
Yes, you can, Nicole. Yeah.
Hi, thank you, David. This is excellent. My question is, when we present possible NEM increases to our employers at annual renewal, they have the option to do that across the board contractually. So let's say they're going from $3,500 a month to $4,000. Right. Does the employer have the obligation to do that? We always strongly suggest it, but is there an actual liability there for the employer if they say, no, I'm not going to do that? If the individual employees want the excess, they have to apply for all of it.
I don't think there's an obligation on them to offer higher non-evidence limits. That's a short answer. I don't think so.
Okay, thank you.
Perfect. And I think that was it. Other than Rick, did you want to see so Rick said, just going back to Canuck, on an appeal, they didn't award costs. So his math looked like Brito would have received $86,664 in the end. Is that correct?
I'd have to do the math to add it all up, but my understanding is that I don't believe, I have to go back and check the Brito case, but I don't believe the cost award was taken out on appeal. I believe that they were still entitled to the $125,000 costs. So just to understand how costs work, the fact that an amount of costs is awarded depends on the retainer agreement and how that works between the lawyer that's handling the case and the client in terms of whether the client keeps the whole $125,000 or whether there's some other formula that applies to that. So that's between the lawyer and the client. The cost award is often less than what a lawyer may charge, or in its rare cases can be more. But most lawyers doing this work are, not all, but many are doing it on a contingency fee basis, and they're getting a percentage of the overall amount recovered. And there's been some case law about that over the years and some changes in the way lawyers are allowed to charge for that. But on the Brito case, I believe that the cost award of $125 was part of the overall amount. As to what Mr. Brito ended up with in his pocket, that I don't know.
Perfect. Thanks, David. Two more, and then I'll pass it over to Blake to do live. Is there a need to reduce overall maximums to NEM because there's a group of employees who refuse to apply excuse me, for coverage above the NEM. And Chris, you can also pop in if you want to give some more context to that.
Sorry, we've been talking about this a lot, David. Sorry, we've been talking a lot about this. Let's say a company has a $5,000 non-evidence maximum, but the evidence maximum is 8,000.
Yeah.
Is it incumbent upon the employee to fill out the $3,000 difference if they are eligible for $8,000? And if they don't, or they refuse to and they become disabled, could they sue you and say, I didn't understand it, I should have gone $8,000, I can't live on the 5,000?
I think the short answer is that, as I said during my presentation, employees tend to have short memories about these types of things. If it was offered and they refused at the time to fill out the form, just keep a good record of that, because if you have a good record, and what happens, I find, is employees come in and say, I never knew about that. And then when you push them on it, very often they have nothing to prove that they weren't offered that. And if the employer has a good trail of information showing that it was offered and declined, then I think you're okay with that. I mean, I'm not saying that employee, Anthony, wouldn't possibly try to sue, but then you're going on a paper, a documentary discovery fishing expedition to see what the employment file shows versus what the employee may have documented. And if it's a he said, an undocumented verbal conversation, then it becomes very difficult. So in that situation where there isn't anything specific, but the employer can say, well, this is what we did, this is what we usually did, and here's what we always do. I think that that can be a stronger case. I know I'm not really giving you a definitive answer, but that's what I would say about that.
Is that a situation that employer benefits liability coverage would protect the employer as part of their general liability policy?
It may. It depends. I think you'd have to look at the specific wording of how far that type of coverage extends in a CGL policy. But yeah, for employer negligence and administration of benefit plans, yeah, I would encourage everyone to look at their every employer to have a look at their CGL policy to see how far that goes.
And just to carry on that exact conversation, David, so like all of our new plans, we make the NEM just match the overall maximum, and that way there's no buy up. It takes all of that off the table. Is there any big downside from an employer liability standpoint to doing that?
You mean, in other words, the non-evidence maximum is the same as the employee, same as the plan maximum? Yeah, no, I think that minimizes the risk considerably, because you eliminate the whole discussion about any differential. And to me, non-evidence, I mean, some of you may know better than me when that type of thing started to be introduced on policies, but going back the many years that we've done this, it's certainly something that's newer rather than going all the way back 30 years ago. Like NEMs were brought in to find ways to keep the cost down. But if they're not handled properly, you can shift the liability. So yeah, if you're matching the NEM with the plan max, then I think you've eliminated that issue.
Wonderful. Okay, we'll jump into the live questions here, Anthony.
There's a couple more, Blake, though, in the chat too, when you're done.
Okay, perfect.
Sorry, unmuting myself. Yeah, David, there's always legal questions. And I guess the other thing is, if you have it properly documented, that the employee was enrolled on the payroll, they paid, and you haven't enrolled them on the plan, and it's 100% mandatory plan, should the insurer still not be responsible when it's in their contract that all employees are covered? And let's say they're 3 months late. This goes back to that 13 weeks.
Right.
That someone's late because if it is a mandatory plan. If it's a non-mandatory plan, yes. I had a life claim paid because it was a mandatory plan. I know that everyone should be enrolled.
I don't know if I can answer that definitively. I think it's very fact specific in terms of the timing and how the employer administered that. I mean, whether it's mandatory or not, if there is a late enrollment issue, you would hope that the insurer would pick up the slack there. And I think what would happen in a legal case that's filed is that the insurer would definitely be sued, as would the employer, and then there might be a bit of a back and forth between counsel for the employer and for the insurance company as to who's going to pick up that differential. But those are often conversations that we as plaintiff lawyers are not privy to.
And Sean, go ahead.
Thank you. This is great, guys. Thanks for everyone who organized it and for your time today, David. First question for Rob. I forget your wife's name, but I was just curious if that was an individual or a group policy you guys are trying to make a claim on. And then I have a subsequent question for David, if possible.
Oh, you're on mute, Rob.
I'm reading your lips. It looks like it was a group policy. Awesome. Thank you. And then David, we had hate to pull in our fearless leader, Dave Patriarch. He's not in the room, I don't think. But we had a chat in our coffee chat the other day, and he was suggesting, I'm interested to hear your views. He was suggesting that insurers, based on the Blue Cross recent case and ruling, insurers are going to be less likely or have less appetite to go to trial for fear of setting dangerous precedents such as this. I'm curious to hear kind of what your thoughts or views are. Thanks.
Yeah, no, that's a very good point. A very good question. Strangely enough, I would say that 99% of these cases settle out of court. And I think that even before Baker, most LTD insurers don't have a major appetite to take the case to trial. I think that Baker would even make it less likely. We had a case that was proceeding to trial in November, and I won't say which insurer it was. It was not Blue Cross, and this is a case that's been going on for 5 years. This man is now over 65, and without breaching any confidentiality, but the benefits were paid out in full, and there was a much bigger reward. The case could have been settled for half the amount 2 or 3 years ago. But it just the insurer that when they came to mediation just I guess didn't believe the guy, didn't come with real money, and so we fought it out, and it took about 5 years. Strangely enough, though, and we're having this discussion amongst ourselves, and we have cases all over Canada, and we have a few cases in Saskatchewan against something called Saskatchewan Blue Cross, which I think is affiliated with the overall Blue Cross. And they just come to mediations not offering any money. And I was having this dialogue with one of my lawyers, the one who does the Saskatchewan case, saying, I'm wondering, have they not got the memo about Baker and Blue Cross? And there's some really bad evidence in their file about, well, yeah, we know this guy is disabled, but because he didn't take our lump sum offer, we're just not going to pay him. Like things like that are written in the file. And they're just they come and say, well, we'll pay $5,000, take it or leave it. And if not, we'll see you. So it's sort of a delay. But you have to wonder at some point, and maybe they're waiting for the Supreme Court of Canada to rule on this. I don't know. But I think most insurers have paid very close attention to what happened in Baker. And I think so for instance, I know there's people from RBC here today, and I don't know how involved they are in litigation, maybe not all that involved at all, but I think that they would acknowledge that RBC, when they're involved in litigation, will try to deal with the case in a responsible way. In litigation doesn't mean caving and paying whatever we ask, but try to deal with the case on the merits and deal with it rather than going to trial and make somebody wait for 5 or 6 years to deal with this thing. It doesn't make Canadians any more likely to fall in love with insurance companies as a result of that. I mean, I'm sure they love lawyers, but that's a whole other situation we could talk about.
Yeah. But I'll finish up the live questions here with just a question for you, David. Given that there's a lot of group benefit brokers on the call, and a lot of times we're just told there's a lawsuit and it's too late, but sometimes, especially if it's the owner's spouse or our main contact of the company, someone going on LTD, and they get that claim denial and they come to us, the broker. Like, what would you suggest we do? Should we call someone in your office and just try to have a quick chat about next steps, or as the broker standpoint, when the client involves us in an LTD denial, what should our next steps be?
Well, obviously the issue of client confidentiality and all that sort of thing has to be addressed as to whether your client wants you to speak to us about it. But by all means, if you think that you can be the go-between in terms of at least getting some preliminary information. We're happy to answer questions just like I'm doing today. You may not get me, but there's other people that may answer those questions. And obviously, if we can help them, then we're happy to see what we can do for people. And I don't know. I mean, brokers I know sometimes do try and get involved and assist, maybe at the appeal level, so that something can be done before it has to go legal. And if you guys can assist with that, and we can guide you in some ways, then we're happy to provide some preliminary information. Obviously, if we don't get all the details and don't look over the whole file, we can't really guide you on a case that we're not actually representing the individuals for. But by all means, part of the reason I agreed to come here is to let people know that we're out there. And although sometimes it feels like if you're a broker, maybe you could get sued if you miss something too. We're all professionals. That can happen to anybody. But we're here to try and help people get what they're entitled to, which I guess is what you want for your clients as well.
Perfect. All right. We'll sneak you in, Bill, and then we'll go back to you, Lindsay, for the wrap up.
Yeah, David, I'm starting to get a lot of cases where, somebody's on LTD, the carrier's saying they're ready to come back to work, but they can't do their job. Like, let's say a janitor, there's no way they can do that, but they can do something else. And they have no job for them. They got nothing for them. So it's like you're stuck between a rock and a hard place. And it's very frustrating for the employers where, they've made do without this person for so long. They kind of hired somebody that's actually better than this person, which is, they don't tell anyone that, and they don't know what to do. It's very frustrating. So I'm just wondering if this has happened a lot with your cases.
Well, a lot of our cases are people that are terminated at the change of definition. And insurers often will do a transferable skills analysis and say, well, if you were a janitor, then I guess you can be a Walmart greeter or something like that. And I agree with what you're saying about the way these policies are set up, even though there are rehab provisions, incentivized things there. Insurers, with all due respect to insurers, they have their mandate and they're not really in the rehab business per se, unless it's completely in their discretion to think that they can rehabilitate somebody. So the point of least resistance is, there's something that you can do. And I say it with the deepest respect, because people that work at RBC or Manulife or Sun Life, they're just doing a job, and their job is to try and get people back to work. But simply saying, well, he can do a sedentary job, a janitor that, has been doing a physical job for his entire career, who has, maybe not even, high school education, isn't going to really be able to get a non-sedentary job when he's 55 years old. Like, who's going to employ him as a, computer network operator when he knows nothing about that? So it's challenging. I would ultimately say, and it's maybe hard to say to your employer clients, but if they are sympathetic to this individual and they are at their wits' end about what to do with them, and they say, they ask what you do, well, just say, we can't really do anything for you about this. Obviously, get advice from your own employment counsel on that. But if you're not happy with how you're being treated by the insurance company, then maybe you should talk to your broker or to a lawyer about what your options are. The employer can't really fall into those shoes, step into those shoes. I wouldn't.
Well, especially the rehab. You talk about rehab. I've had situations where, again, I don't want to put down the carriers. I know they're doing a job, but they say, they have a book and, maybe these are the kind of things you can do. They're not going to help you find a job, but, they just kind of talk to you. And, there are a lot of folks out there that may or not have any other skills. And it's a real challenge. And they just put their arms up in the air and they say, I have to do something. Like, what do I do? And I don't know how far the insurance companies really go with rehab. I don't believe I've heard of some people say, well, you can pump gas, well, I'm not pumping gas, right? Like, I don't know if they actually say that, but they give you a list. It's a book they follow is all they do. And that's very tough for the individual,
Yeah. I understand completely. I don't have any brilliant answers as to what to tell people other than pursue their rights and get what they're entitled to.
Yeah. Thank you.
Thanks.
Okay, we'll fire it over to you, Linz, to get through the last couple of questions here and wrap us up.
Yep, there's just one that I see. And if there's anything after this, please let us know and we can reach out to David. So the last question was, if you reduce your LTD benefit period from age 65 to 2 years, how much notice are you required to give employees? And are you at risk for a liability relating to a long-running disability?
So you mean you're reducing to say age 63?
Age 65 to a 2-year. How much notice do you have to give, and are you risking potential liability relating to it extending past that 2-year reduction to 2 years?
So I just want to be absolutely clear what the question is. You mean you're limiting the amount of benefits to 2 years? Is that what you're saying?
Your LTD benefit period from 65 to 2 years.
Oh.
At the contractual level, I think they're
Yeah, okay.
Yes. Yeah.
If your group has had coverage to age 65, I think what you would want to do is speak to your broker about whether they can offer an individual product to employees and what time frame, so that they're paying the premiums for whatever, or at least giving them an opportunity to get replacement coverage in a timely manner, so that they're not uninsured. And I don't know how quickly that can be done, but I think that it would make a lot of sense, particularly for longer term employees, if you're pulling the rug out from under them on that as much notice as possible to allow them to get replacement coverage, or at least have the opportunity to look into it. That's what I would recommend. I expect that most brokers would be of a similar view to that. I mean, I can't imagine that you're recommending doing that, other than being pushed to do so by your clients because of cost, without telling them there's significant risk if people aren't aware that this change is being made, and giving them sufficient time to get replacement coverage.
Thanks, David. I'm just going to check here. Let's see. Oh, there's one more. I'll read this one out. What is he seeing with claims and the work from home accommodation that employees are taking advantage of? I have clients who feel this is being abused by their employees.
That's an employment law question.
Okay.
Which I will defer to the experts in that area on. And as an employer myself, these are uncharted, difficult times for living in when it comes to figuring out the whole work from home continuum. It's challenging. It's a whole new world out there. But that's really more of an employment law question.
Okay, perfect. Well, thank you to everybody on behalf of myself, Blake, and Jay, and thank you again to all the speakers. We really appreciate you all being here today. It's really amazing to be surrounded by so many passionate and dedicated industry experts. I feel that I'm blessed. I think Blake and Jay feel that way too. A big thank you to the Benefits Trust and to Benefits by Design for sharing our invites to their advisor lists. A reminder of some of the upcoming events. CGIB has one May 8th in Toronto, June 4th in Calgary, and Vancouver is June 6th. Our next agenda-driven webinar or session will be April 16th. And the Benefits Trust has an upcoming Zoomcast, February 6th, 8th, and 14th on building a bulletproof sales plan. So you can register for those on their website. And that's all I have. Thank you to everybody for being here.
Thanks, everyone. Have a great day.
Thank you.